This is part 23 of the revision lecture series on arbitration. In this lecture, we're going to look at the third possible category, that is the third mode of arbitration that is mentioned in the Arbitration Act 1940, and this is pertaining to arbitration in suits, that is arbitration where there is already a suit, there is already a case pending before the courts. So obviously, first and foremost, to differentiate with the previous video where we discussed arbitration with court intervention, please note that here the court is not intervening because the parties, that is one of the parties, is not willing to proceed with the arbitration. On the other hand, what's happening in this scenario is that the court is already present in the scene. That is, the court is already involved and the parties have already filed a suit in court and they are already party to a suit. So a case is already ongoing before the courts, and the difference between this one and the previous one is therefore that in the previous situation where we discussed arbitration with the court's intervention was where one of the parties had to go to the court in order to force another party to proceed with arbitration. But in this situation that we are dealing with in this video, we're talking about a scenario where the parties are both already party to a suit and there's already a case going on. But the parties are not happy, perhaps because the case is taking too long to resolve, or perhaps they're unable to afford the lawyers' fees, or for any reason whatsoever. If the parties to the suit decide, that is the parties to the case decide that they don't want the involvement of the court anymore. So like I said, the court is already involved. It's not like the second mode of arbitration where the court is going to jump in order to rescue that party who is trying to force another party to compel proceeding with the arbitration. So over here the court is not jumping in. Instead, the court is already very much present in this scenario, and now the parties are actually the ones who want to jump out of the court and want to end the litigation. That is, they're fed up perhaps of the litigation proceedings. And by the way, it's not just the time, or that is the length of time that it takes to solve a case that is pending before the court. There are many other reasons why parties to a suit may later on prefer to resolve that matter by arbitration proceedings. So there are many other benefits of arbitration other than the fact that the speed of settlement in arbitration is relatively much faster and the speed is much slower in a court proceeding usually. So arbitration in suits is a situation where there is already a suit pending before the court. So once again, over here the court is present, but please note the difference. I'm not going to repeat it. So in short, in the situation that we discussed in the previous video, the court enters the scene only because it has to help that party who is trying to proceed with the arbitration agreement, and there is one party who is unwilling to solve the matter through arbitration, even though there is a prior arbitration agreement in writing between the two parties. So the court enters the scene only because it wants to help the one of the parties, and obviously it's not like the court enters the scene on its own. One of the parties, that is the party who is trying to force the other party to proceed with arbitration, is going to file an application in court, and I'm going to discuss that relevant section in another video. But remember that obviously one of the parties has to take an action, and only then the court is going to get involved. So that was the situation we discussed in the previous video, and in this video we're discussing arbitration in suits. And over here again the court is involved, but the court is not getting involved at a later stage. The court is involved initially, and it's the court that is going to move out of the picture this time, even though it was there all along. That is, even though the matter originally started in the court, however the matter does not end in the court. Why? Because if, for example, all of the parties to the suit, that is both of the parties, but there can be more than two parties of course. So if all of them, that is all the parties who are party to the suit, party to the case, are going to decide that they want the matter to be resolved, they want the disputes to be resolved through arbitration, then they're going to request the court by filing an application. And if the court decides that the matter is one that can indeed be referred to arbitration, because remember there are certain matters, for example criminal matters, that cannot be resolved through arbitration. So if the court so decides, then that application may be granted and the parties can then proceed to solve their disputes through arbitration. So in short, to summarize, arbitration in suits is where if all of the parties to the suit, because there can be more than one like I said just now, so if all of the parties to the suit, that is to the case, agree that the conflict, that is the matter between them, that is the dispute between them, which is of course the subject matter of the suit, which is the subject matter of the case, should instead be referred to arbitration, then they may at any time before the judgment is passed, that is before the judgment is pronounced by the court itself, they may apply in writing to the court, and we are going to look at the relevant section in a later video. They may apply in writing to the court by way of an application for such an order. Now you may have noticed that I emphasized on the word before judgment is passed. Why? Because it's crucial to remember that this kind of situation can only take place where the court has not yet taken a decision in the matter, that is the court has not yet pronounced judgment in that matter, obviously. So finally, just in case you're interested, the relevant sections are sections 21 to 25 that are contained in chapter 4 of the Act.